Good morning, everybody, and a very warm welcome to you to this Think Legal webinar, Family Law Recap 2023, Navigating Legal Changes in 2023 for a Successful 2024. As I talk to you, I'm just going to add my slides to the studio, if the computer will allow me, and will work with me. And yeah, it's absolutely great to have all of you here today. As my slides are busy processing, it looks like we will have some joy with that. Let me tell you, it's very, very exciting to go through a very interesting year that was 2023 in the realms of family law. We saw quite a few legislative amendments, and we saw some very, very interesting case law that came out. Fantastic. I've got my slides up so we can get cracking. So welcome to this Think Legal webinar. Obviously, feel free to type your questions in the chat bar, comment sections, etc., depending on whether you are watching on StreamYard, LinkedIn, YouTube, or even on Facebook. My lovely wife Nadia is moderating our comments for us. So if you have any questions, comments, or queries, please do type them in the comment box, and we will try to get to them as soon as possible. I see that we've got one or two people in the studio, but that's absolutely fine, no problem. Right, let's get started. So today's webinar, 2023 recap, navigating legal changes in 2023 for a successful 2024. A little bit of housekeeping. You'll see on the top right hand of the slide, you will see a QR code. Nadia has also posted a link. I have prepared quite a significant bundle of our case law, which looks like this. We've got, I think it's about 500 pages worth of case law, which is the case law that we're going through today. I've also made a bundle of legislation containing the Children's Act and the Domestic Violence Act as amended, and a schedule with the main points of the case law that we're going through, as well as our slides. That is a paid resource. It is 250 Rand, just because it took quite a long time to make. You don't need it to enjoy the webinar today, but if you are interested in following along on the paginated bundles and you want it as a resource for your practice, please follow Nadia's link over to our Shopify store, and you can purchase and download the material for 250 Rand. So, what is Think Legal as we get cracking today? We believe in legal knowledge that is open to everyone. It is an initiative which I launched through my practice for Mervyn attorneys a few years back, just shortly post-COVID and / during the COVID time. While we acknowledge that the delivery of legal services is for the most part a commercial venture, we uphold the notion that legal knowledge is a public resource meant to be freely available to everyone. Adhering to our dedication to facilitate open dialogue and share legal knowledge among professionals, we organize a variety of activities, including the management of our 2 WhatsApp groups, hosting regular webinars, and arranging social events. If you want to get involved with the Think Legal initiative in terms of our free resources, you are more than welcome to join the Think Legal Family Law WhatsApp group. It is a group of approximately 500 family professionals, strictly moderated by myself and Nadia, but more strictly by Nadia than myself. But you are welcome to join us there. You can obviously scan the QR code and join us on that WhatsApp group. And then we have the Think Legal Commercial Litigation and Labor Law WhatsApp group, which is also a free resource, which is free to join. You can either scan the QR code on the screen, or you can uh, just follow the link that is shared by Nadia. Nadia, just a quick note. I see that we've got some people that have come into the studio. I think the link that you have shared might be the one for studio guests, which is not the end of the world. This is the watch link. I've just pasted it in the comments. If you can perhaps please share that one. I think there was just a little bit of an issue on Bitly when we did the links. Right, so Think Legal, supported by Lawbox Practice Management Software by lawyers for lawyers. Go to lawbox.coza and try Lawbox for free for 14 days. No credit card or downloads required, as well as for Million attorneys. Right, final plug, folks, and then we'll get into the very substantial content of today's webinar. I am presenting a paid course from 27 to 29 February 2024. The reason that it is a paid course is because it is accredited for a whopping 6 SARM NABFAM CPD points. The course is called Divorce 101. It is divided into 3 2-hour sessions, each session followed by a short evaluation to earn your CPD points. Session 1, we delve into the basics of divorce in South Africa, look at the legal requirements, structure of divorce courts, the powers of the courts. Session 2, we look at the substantive issues such as parental responsibilities and rights, proprietary consequences, including division of joint estates, accrual calculations, and spousal maintenance claims, as well as some of the more oblique and peripheral kind of issues which we don't always deal with, such as the Actio Communi Dividundo, universal partnerships, and also Section 7(3) claims, which we'll also deal with a little bit later in this webinar. And then finally, Session 3, we learn about the divorce procedure in South African courts, covering both uncontested and contested divorce process, Rule 43, and financial disclosure requirements in Johannesburg and Pretoria High Courts. Standard ticket, $750 per person. We have made a concession for candidate attorneys. That is 500 Rand per person. There is a promo code active this weekend. Recap 2023 is the promo code you can use to book on Quicket, and that will give you 20% off your registration. The tickets are going quite quickly, so please do ensure that you do not miss out. Right. Without further ado, folks, let's go into part 1 of the webinar today. And the first section I'm going to be dealing with is legislation and legislative amendments. As some of you may know, the 2 real big legislative amendments that we had in 2023, or that at least came into effect in 2023, was the amendment to the Children's Act, and then also a very substantial amendment to the Domestic Violence Act. And we will go through the 2 of them very, very briefly. So Act 17 of 2022 was known as the Children's Amendment Act. For those of you who are following along on the webinar resources in your legislation bundle, on page 1 you can find the Children's Act as amended. Analyse says try to scan the QR codes. Nadia will post the links shortly, so don't fret if you are struggling with the QR codes, and that is just the codes to join the WhatsApps. Nadia will post it in a second on the YouTube comments where you are watching. Right, so the amendment to the Children's Act was published all the way back in 2022. It was gazetted, assented to by the president, and we then went into a holding pattern where we were all waiting with bated breath for the proclamation of the amendment by the minister, and that then took place on the 8th of November 2023, and obviously the legislation that is amended is the Children's Act 38 of 2005. Now, this is a fairly short amendment, a fairly on face value, simple amendment, open quote, close quote, but it is a profound amendment because, as we see in the preamble to the amendment, or the purpose thereof, to amend the Children's Act so as to amend and insert certain definitions, and I've put in bold and underlined, to extend the children's court jurisdiction. And that is what I'm going to be focusing on this morning. And essentially, if I can give you a very short TLDR summary, the Children's Court can now adjudicate certain matters relating to guardianship of a child. And it's very important to note, folks, that it can adjudicate certain matters relating to guardianship and not all matters, which I will deal with very, very shortly. So, if we look at section 24, this is one of the first profound sections that is amended. Subsection 1, any person having an interest in the care, well-being, and development of a child may apply to the High Court and inserted by the amendment or Children's Court for an order granting guardianship of the child. Now, what this essentially means is a person wanting to apply for guardianship of a child can now approach the Children's Court and is not bound to apply to the High Court. I did a blog on this a while back. For some of you who would like to read up a bit more about this, you can go to vermeulenlaw.co.za, and the blog will be there setting out benefits and, in my opinion, some of the drawbacks. In short, obviously, this is a great win for access to justice. One of the concerns, however, in respect of this amendment is the potential bogging down of the court roles within the Children's Court, which is already highly strained. Second concern in terms of the amendment is obviously that magistrates are a creature of statute. They do not have inherent jurisdiction, such as the High Court does, and very often dealing with matters incidental to guardianship, it does make sense for further types of orders to be granted, which may follow from inherent jurisdiction. Then, if we look at section 45 of the Children's Act, we will see, in terms of this previous section that we looked at, insertion of subparagraph B, capital A, guardianship of a child as contemplated in section 24, which we just had a look at in the previous slide. Then what we must also take very, very careful note of, and I'm going to take myself off My apologies, folks. I removed myself from the stage. Right. So if you look at section 3B, and let me just move myself out the way, I think that will perhaps be a little bit easier. There we go. The High Court, Children's Court, and Regional Court now have concurrent jurisdiction over the exercise, extension, restriction, suspension, or termination of guardianship in respect of a child. My apologies for the dip in sound, folks. I removed myself from the stage so you could see the slide, not taking care to bear in mind that that would mean that my sound would be gone. So sorry about that. For those of you who know the Children's Act quite well, you will know that this refers to Section 28 of the Children's Act, which allows a competent court to make various orders regarding suspension, termination, etc., in respect of parental responsibilities and rights. So we now know that in terms of Section 24, as read with Section 45, sub 1, sub B, capital A, the Children's Court can assign guardianship to an interested person. We now know in terms of Section 28, as read with subsection 3, capital B of Section 45, that the Children's Court can suspend or terminate guardianship in respect of a child. However, folks, there is what appears to be, at first glance, a lacuna in the law. If we look at subsection 3, sub D and E, and please make a very solid note on this, because this can be very problematic in practice. And the section reads that pending the establishment of family courts by an act of parliament, and we know that there has been no establishment of family courts, and this is not referring, folks, to the family court that sits within the Johannesburg High Court. This is a family court by an act of parliament. The high courts have exclusive jurisdiction over the following matters, and that is, look at sub D and sub E, and I've put an exclamation mark next to it: departure, removal, or abduction of a child from the Republic. So if we talk about that, we are talking about our Section 18(3)(c)(3) guardianship function, which, as you know, would need the consent of all holders of guardianship, which in terms of Section 18(5) can be waived if a competent court orders that such consent be waived. So do not bring Section 18(5) applications for consent to travel, relocate internationally, etc., in terms of a children's court application. Understand that those will still be dealt with in a high court. Seemingly nonsensical, because if the high court, for example, terminates guardianship in terms of Section 3, subsection 3, capital B, it would follow that the remaining guardian could travel without any further ado. In my opinion, my 2 cents, is if one reads sub D and sub E together, it would appear that the intent here is not to encroach on the obligations of the High Court in terms of Hague Convention matters and the Hague Convention on International Child Abduction. That being said, it is a problematic section that the Children's Court, or a problematic thing that the Children's Court can giveth, and the Children's Court can taketh away, but the Children's Court cannot give consent to traveling abroad in respect of a child. Very important development, folks, in our law. The Children's Court can now adjudicate guardianship matters, or some guardianship matters. So next up, we look at the Domestic Violence Amendment Act, which for those following along in the webinar resources can be found in the legislation bundle on page 100. The Amendment Act was Act 14 of 2021, and it amends the Domestic Violence Act 116 of 1998. It came into effect by proclamation on 14 April of last year, and to an extent, from putting my ear to the ground and speaking to colleagues, it really has started finding its feet in terms of how it is being dealt with in the courts. Very importantly, folks, sections 6 capital A and 19 capital A are not yet in effect. All of the other provisions of the Domestic Violence Amendment Act are now in effect as of 14 April 2023. So here is our TLDR summary, and a TLDR summary is very important in this one because it is a very, very substantial amendment to the Domestic Violence Act. It is simply impossible in a 90-minute session where the stage is shared with other legislation, case law, etc., for us to properly go through each and every amendment made to the Domestic Violence Act. I will therefore keep it quite brief, and I might mention all of these things I'm going through in a fairly rapid pace because there is quite a lot. This is not, this webinar obviously is not a substitute to going and reading and studying yourself. At best, I can tell you where to look and what to look out for. So, in our summary, the DV Act was given a major overhaul. New forms of domestic violence were introduced. New concepts altogether were introduced, and the burden of proof in ex parte matters was amended. And the duties to report alleged domestic violence was extended, and additional duties were imposed. Raquel asks how to get the bundle. Raquel, you'll note Nadia has just pasted on the comments the link. The notes and the bundles are available on Shopify. It is an optional extra if you would like to get hold of those. I don't know if the comments that Nadia is posting on StreamYard is going through to LinkedIn as well. So Nadia, maybe just check, if you don't mind, on YouTube, Facebook, and LinkedIn that what you are posting is going through to the participants on those platforms as well. So, folks, as I said, the DV Act was given a major overhaul. We had new forms of domestic violence, which we will look at shortly. We had some new concepts which came in, very interesting new concepts, and we had an amendment to the burden of proof in ex parte matters, and we now have duties to report alleged domestic violence. So, let me move myself to the side this time and not necessarily take myself off to mute myself. So, under the definitions clause of the Domestic Violence Act, we have a good list of what constitutes domestic violence under the Act. Now, what I have done, folks, is I've gone through the amendment and I've just in bold indicated which are the new concepts. So physical abuse, sexual abuse, emotional, verbal, or psychological abuse, economic abuse, intimidation, and harassment are all existing concepts. In terms of the definition of emotional, verbal, and psychological abuse, that has changed, but it is not a new concept necessarily. I see that someone's posting that they can't hear me. Can I just check if those of you who don't mind, can you just confirm that you are hearing me? And then, fantastic. Okay. I am being heard. So our new forms of domestic violence. F capital A, sexual harassment. F capital B, related person abuse. We have now spiritual abuse, damage to property, elder abuse, coercive behavior, controlling behavior, exposing a child to domestic violence. And then we've also got a big expansion to subsection I, which is used to be entry into a complainant's residence. So it has now been expanded very, very significantly, that it includes entry into a complainant's permanent or temporary residence without their consent, into their workplace or place of study without their consent, and then our sub J, which used to be any other behavior, has also been broadened to include intimidating, threatening, abusive, degrading, offensive, or humiliating nature towards a complainant where such conduct harms or inspires the reasonable belief that harm may be caused to the complainant. So it is worthwhile, folks, to go to the Domestic Violence Act if you can find it online. I had some serious trouble finding the amended act online where it's not behind a paywall. So for those of you who do have it, that it was not behind a paywall, please do reach out on the WhatsApp groups and let us know where we can find it for those who do not have paid subscriptions. But if you get your hands on the amended Domestic Violence Act, have a look at these definitions for each new open quote, close quote form of domestic violence. It is worth a read. They really have tried to close quite a lot of loopholes within the Act and ambiguities within the Act. And obviously, they've thrown the net quite a lot wider in terms of forms of domestic violence. Then, okay, my text has gone a little bit funny here for some reason. Section 2, capital A, folks, very, very important. This is a duty to report section. A functionary who in the course of performance of their duties or the exercise of their functions obtains information which after evaluation causes them to believe or suspect on reasonable grounds that a child, a person with disability, or an older person may be a complainant, i.e., someone who is enduring domestic violence, must without delay complete a report in the prescribed form setting out the reasons for such belief or suspicion. 2, in the prescribed manner, submit the report to a social worker or a member of the SAPS. B, must conduct a risk assessment as contemplated in Section 18B and may, after the evaluation of the risk assessment, provide or refer the complainant for further services as contemplated in Section 18 Cap B. Functionary, for now, it is a concept where they can be designated by the minister, I believe. But for now, in terms of the definitions in the Act of Functioning, means a medical practitioner, healthcare personnel, a social worker, an official in the employ of public health establishment, an educator, or a caregiver. So very important, folks. Section 2, capital A, imposes an obligation on these functionaries, and I point out and emphasize this includes educators. So our teachers must know about this section. That if they believe on reasonable grounds a child, a person with a disability, or an older person may be a complainant, they must report this. Now, what is the purpose of this section? It is to protect the most vulnerable of the vulnerable within society. These 3 categories of persons, obviously they are not the only categories of persons, but they are specific categories of persons who do not necessarily have the ability to report domestic violence themselves. Now, Section 2B is very, very broad, folks. And now this is something that I think we all need to take very, very careful heed of. So in circumstances other than those contemplated in Section 2 capital A2, and you'll remember 2 capital A2 refers to a functionary, which is a defined person. An adult person, and now this is broad, an adult person, any adult person who knows or believes or suspects on reasonable grounds that an act of domestic violence has been committed against a child, a person with a disability, or an older person must report such knowledge, belief, or suspicion as soon as possible to a social worker or the South African Police Service. Now, very, very interesting. This does not specify whether the report must be made to a DSD social worker or a social worker in private practice, but we will get more clarity as this goes on. Michael asks, does not force reporting of violence against, say, a wife? So the Act does not necessarily force a person to report domestic violence against, let's call it an adult person who has full legal capacity. The reason being that obviously in terms of what the Act envisages is that your children, older persons, or persons with disabilities are people who cannot necessarily get the relief themselves. However, this does not take away from the fact that a person can apply on someone else's behalf for a domestic violence interdict, and there are provisions to make provision for that, and motivations in the application form of why you are applying on someone else's behalf. So it does not force a person to report, but a person who is concerned about another adult person can certainly apply on their behalf. Look at the example, for example, where a perpetrator of domestic violence locks a person in the house, etc. I believe there is a prescribed form. I'm not 100% sure what the form looks like. I think the best would be to consult with the SAPS, for example, or with a social worker. And that falls a little bit out of the purview. I might have a look at a more detailed webinar on the Domestic Violence Act to answer your question, Irina. Kaylee has shared with us the Domestic Violence Act. I do believe, I'm assuming that this is the Act as amended. I'm going to ask Nadia just to reshare Kaylee's comments. So thank you for that, Kaylee. Much appreciated. Guys, please have a look at that and have a look at whether that is the amended Act. And then Heike has shared with us the Domestic Violence Act amendments. I'm assuming, yeah, that is the Amendment Act that Heike has shared there. Nadia will repost those as well. Oh, she's already pinned them. She's way ahead of me. So, guys, have a look at those as free resources out there to assist you in your practice. Section 3 capital A under the Domestic Violence Amendment Act gives the South African Police Services very substantial powers, and this section, folks, scares the daylights out of me, but if utilized for the correct purpose, I do suppose that it has a very important function, and it essentially states that if a member of the SAPS receives a report that an offence containing an element of physical violence has allegedly been committed during an incident of domestic violence, and reasonably suspects that a person who may furnish information regarding that alleged offence is in any private residence, they may, without a warrant, enter the residence for the purpose of interrogating that person and obtaining a statement from them. There are further sections within the amended Act also which give the SAPS powers to enter private residences without a warrant. We'll see what happens in terms of constitutional scrutiny in due course, but essentially one can understand the rationale for it to ensure that the DV Act does not become a dog without teeth. Obviously, it is all subject to the police exercising these functions in a constitutionally sound manner, which we hope will be the case. Then a very interesting concept, folks, in terms of section 4 capital A is a domestic violence safety monitoring notice. The court may, in terms of a DV application, issue a domestic violence safety monitoring notice where they essentially order the station commander of a police station to direct a member of the SAPS under their command for a specific period to do certain things. Contact the complainant at regular intervals to check on their well-being, at regular intervals to visit the joint residence to see and communicate with the complainant, where the member is prevented from seeing the complainant to enter the joint residence to see and communicate with them, and overcome resistance against such entry by using as much force as is reasonably required by the circumstances, including breaking a door or window of the residence. So this domestic violence safety monitoring notice gives very, very big obligations, but also very big powers to the folks in blue to enforce and ensure that these things, that the complainant is looked after. Thank you for showing that. Thank you for Mamakwe for saying that to answer the question earlier. The SAPS do share the referral letters. Mamakwe, if Makwakwe, sorry, my apologies for the pronunciation. It's early on a Friday. Makwake, if you can please, if you have a link for where they can be found, please could you share in a comment, and then Nadia will also just share it with everyone who is watching in terms of the comments, etc. Then something which I find very interesting, which, as you would have noted, a lot of the majority of the amendments that I've looked at so far extend the powers in terms of domestic violence and seem to be very complainant friendly. This amendment to Section 5 of the Act is a little bit more complainant unfriendly, and that is subsection B of subsection 2 under Section 5, which says that in the olden days we had really two legs to get across, or two hurdles to get across before getting an interim protection order, and that was prima facie evidence that the respondent is committing or has committed an act, and the complainant is suffering or may suffer harm as a result. If you in the past could get past those hurdles, then the court was bound, it was peremptory, the court must, not may, issue a protection order. A third requirement has now come in, and that is that the issuing of a protection order is immediately necessary to protect the complainant against the harm contemplated in paragraph A2. And I have no doubt in my mind that this amendment was put in because of the gross manner, and I say gross in capital letters, that the ex parte process in domestic violence court is being abused by unscrupulous litigants. And we see it, unfortunately, on a daily basis, to the extent that magistrates are really inundated with matters where the matters are either brought frivolously or they are brought as a deliberate in terrorem tactic to cause embarrassment, discomfort, etc., or to get a purported leg up in the litigation against a spouse, a partner, or whatever the case may be. Interesting to see how the courts will interpret this. Unfortunately, an extra hurdle for litigants to get over in terms of the ex parte portion, which, as the attorneys who are attending today and the advocates who are attending today will attest, it very often is the luck of the draw in terms of whether you will get your interim protection order or not. And I say that very, very respectfully. I've seen various matters where a lot of evidence is presented under a supporting affidavit and a notice to show cause is issued. And within a week, the very same court will, on a few bald allegations without any proper evidence attached, would then issue an IPO. It is something that we are unfortunately seeing in practice, and it remains to be seen how this subsection B will affect the position going forward. Then that takes care of our legislative updates. Now, folks, I am just looking at those which came into effect last year. I know there were further amendments which were either gazetted or assented to by the president, but if they have not yet come into operation, I'm not dealing with them in this webinar, and I will look at them in a 2024 recap webinar in due course next year. So watch this space. All right. In terms of reported cases, guys, no webinar will ever replace taking the time and reading the case yourself. Okay, this is not case law for lazies. This is just a starting point for you to have a look at the case law yourself. I've looked at all of the reported family law cases that I could find. and I've put in two very important unreported constitutional court cases that we will look at right at the end, which have very, very big implications for family law matters. For those of you who would like to follow along in the bundle, in terms of the reported cases and the unreported cases, you will see, and I will share also the page number in the bundle where you can find it. For those who have an interest in downloading the resources, those who have just joined us, those are available if you scan the QR or follow the link that Nadia will share. It is on our Shopify page. The notes, slides, and copies of the case law and legislation discussed are a paid resource, just because it took me a heck of a long time to compile everything. If you would like to support our Shopify store, it is 250 Rand, and then you will get all of my slides. You will get the case law summary, which gives you in very broad strokes just the gist of the case. You will get our legislation bundle with the amended legislation, and you will get our case law bundle, which you can work through at your own time. The recording, however, folks, will be shared free of charge, as the webinar is free of charge. Right. Let's go through our reported cases, and I'm going to start off, and I've gone through the reported cases chronologically in the order that they were published in the SA law reports. Oh, Neil, thank you. I really appreciate your feedback. Neil says bundle, well worth it. Thank you. Neil, incidentally, I made one or two amendments to one of the documents after putting it up, but I've got everyone who's purchased. I have their email addresses. I'm going to send you some updated documents after the webinar. I just ran out of time. The same goes for anyone who will be purchasing the course material. I will provide you with the updated documents by email. I've gone through the cases chronologically as they appeared in the SA law reports. So I haven't put them in terms of any themes. Some of them are very profound. Some of them are a little bit oddball, if I can use that word. Some of them are highly specific. Some of them are very, very broad. But all of them are important to take note of. The first one I'm going to look at is CB versus DB 2023 1 SA 381 SCA, and that is on Case Law Bundle page 1. Essentially, this SCA matter dealt with an antenuptial contract signed between the spouses, and after the antenuptial contract was signed, they signed another agreement, and the argument essentially came in whether the further agreement was at loggerheads with the antenuptial contract. So the facts, very, very briefly, appellant and respondent executed an ANC specifying marriage out of community without accrual. Subsequently, they signed another agreement stipulating donations and maintenance upon death or divorce. Upon divorce, appellant sought enforcement. Regional Court upheld the agreement's enforceability. High Court overturned that, and they then went to the SCA, and the SCA followed the Regional Court and found that the agreement, the further agreement, was in fact enforceable. I don't know why I've got a funny zoom here on my screen. I apologize. On my slides, which I'm sharing, everything does look in order, but we'll forge ahead. So essentially, there was a distinction between ANCs and separate agreements in matrimonial matters, and it dealt with the interpretation of agreements in the context. It looked at whether the further agreement was at loggerheads with sections 7.1, which deals obviously with settlement agreements, which are made in order of court in divorce, and section 7.2, which gives the court an inherent power to make spousal maintenance orders depending on the laundry list of factors that we have in section 7.2. Court found, I'm not going to go through each and every one of them, the court found essentially that the agreement was valid and upheld it, right? Why is this important? It gives us clarification on the coexistence and enforceability of separate agreements alongside ANCs. It also sets out when such an agreement will be valid and when not. This does not, ladies and gentlemen, very, very importantly, open the door for any type of agreement at loggerheads with an ANC. Go read the case law before you advise that parties can simply sign a different agreement, to say we are married with accrual, and then sign another agreement, say now we are married without accrual. Go and read the case law and understand when you can and when you cannot do those types of agreements. It reinforces the principle that agreements specifically dealing with property and maintenance separate from the matrimonial property regime can be legally binding. And it gives us a precedent for interpretation. Here are some notable quotes from the judgment, which I will share with you on the coexistence of an ANC and a separate agreement. That's on page 6 of the bundle. For those following along, paragraph 9 of the judgment. Two legal instruments can coexist because an ANC regulates the matrimonial regime of the parties stante matrimonio only, whereas the agreement has no bearing at all on the nature of their matrimonial regime, whereas the further agreement has no bearing at all on the nature of the matrimonial regime in respective estates. Then, on application of the Divorce Act, Section 7.1 of the Divorce Act is not applicable, nor is the matter of HM versus AM, which was relied upon by the court. A quote, Section 7.1, folks, for those of you who are interested, is the section that says that the parties can sign a settlement agreement and the court can make it an order of court. So the court is essentially saying this is not a settlement agreement in a divorce. And then further, the agreement does not take away a discretion under Section 7.2, paragraph 15, and you can find that on page 9. I would love to hear your views on CB versus DB 2023, 1 SA 381 SCA. Do you agree with the Supreme Court of Appeal? Do you foresee that this judgment is going to cause any problems going forward? Please share your views with us in the comments. Next matter, Centre for Child Law versus TS and others, 2023 6 SA1, and that is a Constitutional Court judgment. This is an incredibly important judgment. It has been around for some time. It was only reported in the first quarter of 2023, and it is a very, very pivotal judgment for parents who are not married who want to approach the office of the family advocate. For those of you that will recall, before this judgment, it was quite simple in terms of divorce matters. If you want an investigation from the family advocate in a divorce matter, you would simply complete the family advocate, what they call the Annexure B, which is a 2-pager form. You would submit it, and lo and behold, the next thing you would get an email, or the parties would get an email from the office of the family advocate with their appointment details. Not so for unmarried parents. In essence, what one would have to do in those instances previously is one would approach the court on a Part A, Part B, and you would have to get an order that the family advocate investigate. Obviously, if you compare an application to a court of competent jurisdiction with the costs of filling in a 2-pager form, the one is much more substantive, whereas the other is a very, very simple and relatively painless exercise. The question was raised in Centre for Child Law versus TS whether this distinction was unconstitutional. And essentially, the court said yes. The distinction was unconstitutional. It distinguished between married parents and unmarried parents, unduly favoring married or divorcing parents over never married parents, which established indirect discrimination. The court found that the discrimination was unfair. It did not have a legitimate government purpose, and it was therefore unfair and unconstitutional. Now, as the constitutional law buffs between us or among us will know, generally what would happen in most instances is one would not approach the Constitutional Court directly. You would go through the High Court that would make the declaration of being unconstitutional, and the Constitutional Court would then essentially rubber stamp it and confirm the declaration of constitutional invalidity. The Constitutional Court did so, and we now have a position where the family advocate can or should be approached on the same basis. Now, the court provided a 24-month suspension for Parliament to amend the Act ensuring compliance with constitutional standards, as is very often the case, as you'll see in one of our matters, which we will look at a little bit later as well under our unreported section. Now, two very interesting notable quotes: discriminates against unmarried parents, including unmarried fathers. Its office therefore recognizes the fact that unmarried parents have no choice but to obtain a court order to direct the FAO to conduct an investigation into what is in the best interest of the minor children. This is from paragraph 27 of the High Court judgment. And section 4 limits sections 9.1 and 9.3 of the Bill of Rights, and this limitation was not justifiable in terms of section 36 of the Constitution. That's from paragraph 58 of the judgment. You can find that on page 40 of the paginated bundle for those of you who have purchased the resources. And this really is the reasoning of the court. It unjustifiably limits section 9.1 and 9.3 of the Bill of Rights. Right. Moving swiftly down to the Western Cape High Court. Now, this is quite an interesting matter dealing with Rule 43. For those of you following along in the case law bundle, and we are moving at a very swift pace, we've still got quite a few slides to go through. It is now 10 to 10. I think we'll make it for 10:30 to be done by then. I'm going to try my absolute best. And now we know, folks, that the SCA ruled on the issue of maintenance for major dependent children and the locus standi for the other parent to approach the court. So we had an interesting slew of judgments starting quite a while back, and I do believe it was Bursey versus Bursey that the court said that, the duty to maintain a child does not fall away when they turn 18, etc. Then came Z versus Z in the SCA, that really edified the position that a parent can claim maintenance on behalf of a major dependent child in divorce proceedings. Then came the I think it was the George Circuit Court. Anyone who has that citation, please could you post it for us? I don't have the citation handy, that said that a parent can also go to maintenance court or can litigate in the maintenance court on behalf of a child. Now came a very interesting following judgment, CL versus CJL, which Villa J dealt with, and that is whether you could claim interim maintenance for a child who is a major dependent in terms of Rule 43. So it does not establish whether you can claim maintenance for a major dependent, or on my reading at least of the case, and you can tell me in the comments if you agree with me or not, whether you can claim on behalf of a major dependent child in Rule 43, and if so, what hoops must you jump? So essentially the facts were as follows. Parties were in a divorce with one adult dependent child. Applicant sought maintenance pendente lite from respondent in a Rule 43. Respondent argued that the child, being a major, had her own locus standi to claim maintenance. Don't we see that all the bloomin' time? The court was to determine whether the applicant could claim maintenance on behalf of the adult dependent child in the context of a Rule 43, pendente lite, in other words. So what did the court say? The court really said essentially an adult dependent child does retain locus standi in maintenance claims. In other words, the child has legal standing to claim. The child should be joined in the proceedings at least, at least provide a confirmatory affidavit, and obviously the legal position that parents' duty to support does not automatically cease upon reaching majority was edified. Now, here are some notable quotes. I had to read it over a few times to really get it in my head nicely, but notable quotes on locus standi and adult dependent children. The adult dependent child in these circumstances, and please, for those of you who are following along on page 60 or who have the case open, please just be very careful to highlight in these circumstances, should retain his or her locus standi and accordingly fails to be joined. Falls to be joined, not fails to be joined, or must at the very least file a confirmatory affidavit in any pendente lite proceeding in which his or her parents may be involved. Why is this? Essentially, it's this. Let's say mom and child are sitting in cahoots, or dad and child are sitting in cahoots, whomever claims maintenance on behalf of the child. Party one runs to the Rule 43 court, gets an order. They're not happy with that order. The child can then run to maintenance court, hoping to get a better order, and they can then cherry pick the order. And I would say on page 54, paragraph, I think it's paragraph 16. Yes, paragraph 16. It's very interesting. Judge Villa starts off by saying, I love this quote. I just put it in because it amused me. This entire subject is one of depressing complexity. I really enjoyed that. But importantly, paragraph 40 on page 59, coming back to my point, this will enable courts to finalize interim maintenance claims for all parties concerned, preventing an adult child from having to bring discrete maintenance claims against his or her parents. So for those doing Rule 43s, where major dependent children are involved, err on the side of caution and ensure that you get at least a confirmatory affidavit and attach it to your founding affidavit. Right, now we're getting into pension fund territory, and both of the pension fund matters that I'm going to be dealing with today are quite tricky, so I cannot give you the whole nub of absolutely everything. It is important. Go and read the judgments yourself. For those who have the case law bundle, you can find it on page 62. And here we are dealing with CNN versus NN 2023-5 SA 199. And this comes all the way from sunny Johannesburg. So GLD, as it was, I think this was it was still known as GLD at that stage. It revolves around the intricacies of dividing pension benefits on divorce. So it was about the enforceability of a divorce settlement agreement, particularly concerning allocation of pension benefits. And it was essentially a application by an aggrieved party post-divorce to alter the divorce order to claim accrued pension benefit instead of pension interest. Unfortunately, they went home empty-handed, and the judge was alive to the fact that the legislation is unfair, open quote, close quote. But in terms of the legislative framework, the court could not help the applicant even on an unopposed basis. So essentially, the divorce order between applicant and respondent included a settlement agreement allocating the applicant 50% of the respondent's pension interest. After the divorce, the respondent resigned from his employment and exited the fund, leading to the transformation of his pension interest into accrued pension benefits. And then I believe there was also a part of that was commuted, the 1/3, if memory serves. The pension fund informed the applicant that the divorce order did not meet the legislative requirements for claiming a share of the accrued pension benefits. The court looked at section 7.7 and 7.8 of the Divorce Act, which deals obviously with pension benefits, pension interest, not pension benefits. Be very careful. And obviously, in terms of the Act, it is considered an asset of the divorcing party and is subject to division. Right. Crucial distinction was made between pension interest and pension benefits and accrued pension benefits. And essentially, the Divorce Act only provides for the sharing of pension interest and not accrued pension benefits. The court couldn't help the applicant even on an unopposed basis. And here are our takeaways. It highlights the complexity of and the pitfalls in dividing pension benefits in divorce proceedings. It underscores the importance of accurately understanding and defining pension terms in divorce settlements and closing the loopholes for unscrupulous litigants. And it also tells us about potential legislative gaps. But for us mere mortals working within the system and not designing the system, that is probably not going to change anytime soon. Unfortunately, here are our notable quotes. The applicant seeks to modify an order that was made by the court that was not aware of the respondent's fund membership status at the time the order was made. In essence, the respondent caught the applicant with a fast one. And this is page 69, paragraph 17. And here the court, I think it was Marumukhai A.J., who wrote the judgment, if my memory serves, the current legal position allows unscrupulous member spouses to deliberately prejudice their non-member spouse's claim to their retirement benefits, quote, by resigning from their work after being served with divorce summons. We know that the SCA has made provision in terms of living annuities for those to also be reckoned in certain instances. But I think the judge was perfectly correct in saying that unscrupulous spouses have a lot of power in terms of the legislation as it stands now. And then under the third one, non-member spouses can only then claim part of their member spousal contributions plus investments, which will be conveniently referred to as pension interests for the purpose of divorce. Page 81, paragraph 36. Grim prognosis in terms of settling pension issues after divorce. I'm just going to move my camera, but I see my lighting is a bit funny. Right, now here is an interesting one also in terms of pension interests. Case law bundle, page 84, for those who are following along. De Graaf NO versus CS 2023 6 SA 374. Those of you who are quite astute will note that Mr. De Graaf's name is not abbreviated because he was cited in his representative capacity, and essentially he was cited as the executor of the estate of the respondent's late ex-husband. This matter came down to the interpretation of a divorce consent paper. I'm assuming that it was appealed from the Cape, as they refer to their settlement agreements as consent papers. And essentially the High Court ruled in favor of the respondent, Mrs., and against the executor, and that was then taken on appeal. What it came down to is essentially the following. What portion of the pension interest was Mrs. entitled to after divorce? And there was a question of whether it fell within the divisible pension interest in terms of section 7.7 and 7.8, or whether it was over and above. The SCA found that the clauses were clear and unambiguous. High Court said that they were ambiguous, and essentially the SCA went against Mrs. and said that she was only entitled to 50% of the 1/3 which was available to the deceased at the time of his withdrawal from the pension fund minus tax, the commutable pension interest. Then the notable quotes, which I'm going to refer to, and I'm not going to go too much into the law section of it. I'm just going to look at in terms of how the SCA interpreted the agreement. The SCA found that the impugned clauses were unambiguous and they were clear. Page 93, paragraph 18, and that the respondent is entitled only to 50% of 1/3 of the net pension benefit. that the deceased was entitled to that portion which could have been commuted, which I referred to earlier. And then obviously the court looked at the contractual intention of the parties, and it was clearly expressed. That's in clauses 9.4 and 9.7 of the agreement, and that's dealt with in paragraph 19 of the judgment, page 94. Guys, what is our takeaway from this judgment? Now, look, it's very complex, and I know most of you will be scratching your head and saying, look, what was this guy saying? I don't understand what this judgment says. As I mentioned earlier, some of these are very, very complex. Go and read the judgment for the context yourself. We've got 25 minutes left. We have to go through a lot. I can't go into a heck of a lot of detail. But take the following away with you. Precision in drafting divorce consent papers is essential, especially concerning pension benefits. Be careful when drafting these documents. They are highly regulated in terms of statute and in terms of the rules of the specific funds. It is not a one-size-fits-all, and it can be very complex. And understand that you need to be mindful of the pension fund rules when you talk about the entitlements. Don't just read the legislation, read the rules as well. Right, JK versus Swartz. Once again, Mr. Swartz, not cited, abbreviated. His citation in this case was essentially he was cited as the receiver and liquidator on behalf of a joint estate. Those following along, case law bundle, page 98. And we're looking at JK versus Swartz and others, 2023, 6 SA 500 GJ, all the way from Johannesburg. Facts were the following. Mr. and Mrs. were divorced with a joint estate to be divided. Mr. Swartz was appointed as the liquidator. Final L&D allocated $988,000 to be paid to a pension fund nominated by the applicant from Mr. K's pension fund. The applicant later demanded the amount in cash, leading to disputes and a High Court order directing Mr. Swartz to realize assets to pay her $940,000 odd in cash because she didn't want to withdraw from the fund for some reason. And I'm assuming the 940 is equal to 988 less tax, I'm assuming. So Mr. Swartz then was unable to comply with the order. He couldn't or wouldn't, I'm not sure 100%, realize the assets to pay the amount in cash. Oh, my apologies. It was the L&D allocated this to be paid to a pension fund nominated by her, but she wanted it in cash. Apologies. Right. So then Mrs. wanted to declare Mr. Swartz in contempt of court because the funds were not paid in cash. Right. The question was whether Mr. Swartz was within his power, whether he had the power to realize these assets or not. And essentially, what the court looked at was the fact that Pension Funds Act and Divorce Act provide that pension interests are a deemed asset. They are not a de facto asset that you have in your hands. It is a deemed asset. It's deemed to be part of your assets. And it can only be divided in terms of the provisions of Section 7778, etc., of the Divorce Act and the Pension Funds Act, specific provisions in terms of how the division is done. And essentially what the court said is that Mr. Swartz did not have the power to just deal with a pension fund as if it was another asset, right? And I'm going to look at the notable quotes, just take my face off the screen so you can see nicely. Pension fund benefits are different matters. Such benefits are statutorily regulated. They may not be attached, reduced, or transferred. That's page 114, paragraph 71 of the bundle. Then paragraph 72, it follows, a pension benefit is not in fact an asset and cannot be dealt with under Mr. Swartz's general powers of receivership and liquidation as set out in the divorce order. And then finally, there's paragraph 62, page 112. Sorry for it cutting off on the way that it's displaying here. that a party cannot be willfully in contempt of an order that was impossible of compliance. The verbatim, Mr. Swart cannot be willfully in contempt of an order that it was impossible of compliance. So very interesting. JK versus Swartz and others. Let's go back to the Western Cape High Court to a relocation matter, and this is on the case law bundle, page 122, MH versus OT 2023 3 SA 159. Mother wanted to relocate to the Netherlands against the father's wishes. The application was granted, and we will go through the reasons shortly. Applicant and respondent were both Dutch citizens, never married. The child K, a 5-year-old boy, born in 2013. The parties were locked in an ongoing conflict, primarily concerning the child. Mom sought permission to relocate to the Netherlands, with K, the father, finally supported by the family advocate, opposed the relocation. What did the court look at? First off, paramountcy of the child's best interests as enshrined in Section 28 of the Constitution. It looked at the interpretation and application of PRR under the Children's Act, and it looked at the legal standards for considering international relocations. First off, the court found the mom's reasons were bona fide and reasonable. That is a recurring theme, folks, in relocation matters. If you deal with relocation matters, always make sure that you deal with deal with the fact of whether the relocation is bona fide and reasonable under the circumstances. The court looked at the ongoing conflict between the parents and actually said that it was detrimental to the child's well-being, and recognized the child's right to an environment free from parental conflict. And the court also ordered certain safeguards to ensure the father's contact post-relocation. So, practical implications. Always, children's matters, emphasis is on the child's best interest. Read Section 7 of the Children's Act, know Section 7 of the Children's Act, memorize Section 7 of the Children's Act if you have to. And also, it sets and follows certain precedents in terms of handling cases in terms of relocation. As I mentioned, the bona fide and reasonable nature of the reasons for the relocation. And then also, obviously, it highlights the need to balance the relocating parent with a non-relocating parent and the child's rights. The court went back and quoted Jackson versus Jackson. I put it in just because I thought it was an interesting quote. It is tried that in matters of this kind, the interests of children are the first and paramount consideration. And that is an SCA judgment quote. That's on paragraph 45 of the judgment, page 139. And then to illustrate the emphasis on bona fide or not bona fide in terms of the relocation, I quote from paragraph 58, page 145. Mom's reasons for wishing to relocate are bona fide and are certainly not unreasonable. Okay. MN versus BN, page 147, all the way from the Free State, Bloemfontein. MN versus BN 2023 5 SA 519. Long judgment. For those of you who have a few hours and a lot of bravery to burn, go read the judgment. Essentially, what it went on was plaintiff and defendant were married. Later on, plaintiff discovered he was not the biological father of their daughter, born in 1997, following a DNA test conducted 3 years after divorce. He claimed damages for maintenance paid for the child, alleging fraudulent misrepresentation and non-disclosure by BN concerning N's paternity. BN did not dispute the DNA test, but argued against the claim based on public policy and lack of fraudulent intent. Unfortunately for plaintiff MN, the court essentially found for the defendant, saying that no legal duty exists for a spouse to disclose an extramarital affair. Misrepresentation claims require proof of intentional falsehood by the representor, and he could not prove that mom had intentionally misrepresented the paternity of the child, and further, the refund for child maintenance was contra bonus mores. And notable quotes. In addition to my findings that the plaintiff did not prove his claim on the basis of fraud, I furthermore find that his claim is contra bonus mores and against public policy, and can for this reason and or in any event not succeed. That's paragraph 199 of the judgment. I told you it's a very long judgment, and that's on page 208 of the bundle. RC versus HSC 2023 from Johannesburg, case law bundle, page 220 for those who are following in the bundle. It dealt with the issue of a non-biological parent seeking guardianship and contact rights over a minor child. RC and HSC met on Tinder, lived together with HSC's two children, B and D, from December 2018 to 2021. RC formed a strong bond with B, who was born during HSC's pregnancy when they met. Post-separation, an informal agreement allowed RC contact, which HSC later revoked, so RC filed an application for guardianship and contact rights under Section 23 and 24. The trial court essentially dismissed the application. So that was the trial court and the High Court. If memory serves, this was an appeal to the full bench. The court overturned the decision, recognizing RC's relationship with the child and his status as an interested person under the Children's Act. And essentially, the court said that the lower court, the trial court, failed to consider the best interest of the child adequately and did not utilize a child-centered approach. And a couple of quotes here. It is now settled law that the absence of a biological link is not a bar to an application in terms of Section 23, subject, of course, to the best interest. Paragraph 32, page 282. And essentially, and I didn't quote this, I've given you the gist of it, a child-centered approach was called for. Courts should be slow to determine facts by way of the usual opposed motion approach. That approach was not appropriate if it left serious issues disputed, relevant to the child's welfare, and if those were still unresolved. So, very, very interesting case regarding guardianship, where there is no termination of the existing guardian's guardianship, or no case made out that they are not a legally sound or an appropriate guardian. Right. I think this is our last of the reported judgments. And for those following along, you can go to Case Law Bundle, page 242. SH versus MH 2023, 6 SA 279, Gauteng, Johannesburg. And this was by Victor J. It was a Rule 43 application. This, folks, is an NBNB judgment to read. It deals with various issues in terms of Rule 43, but I'm going to look at the constitutional prism called for by the court in determining contributions to legal costs. And essentially, the court found in a very substantial judgment, and it seems that this judgment is being followed very broadly and is not enjoying quite a lot of criticism, or is not enduring much criticism, I think is a better way. Enjoying criticism, it's my Afrikaans coming through there, my apologies. Rule 43 must be interpreted through a constitutional prism, particularly regarding the right to equality and access to justice. Equality of arms is central, ensuring both parties can present their case effectively. Rule 43 allows for the contribution towards legal costs, which can be partial or full, depending on each party's financial capability, and the need to ensure equality of arms. Very important judgment in terms of the gender considerations of, let's face it, realistically, very often, and in most cases, it is still the wife applying for Rule 43, and there is a very big gender disparity in terms of means. And this is a big win for previously disenfranchised spouses, vulnerable spouses, whether male or female, or whatever the format or the setup of the domestic relationship is. So, notable quotes, paragraph 101. Apologies, I didn't put the page number in there. The real question, which lies at the heart of Rule 43, and upon which all such applications should turn, is whether the spouse, most often the wife, is able to defend her case with an arm that is as long and a purse that is as deep. And obviously, it's the more financially vulnerable spouse, usually wives, who disproportionately bear the brunt of all this. Very important matter regarding Rule 43. Now, folks, the comments have gone very quiet recently. I'd love to hear from some of you in the comments or in the chat what your thoughts are on this judgment. Are you generally acting for Mr. Moneybags or Mr. Moneybags' spouse? What is your view on this, and how do you see it playing out in the long term? Right. It underscores the court's role in facilitating access to justice, especially for financially disadvantaged spouses. And the reasoning, as I mentioned, the real question which lies at the heart of Rule 43 is whether the spouse is able to defend their case with an arm that is as long and a purse that is as deep. Right. Let's go on to our two as yet unreported cases, and we've got 9 minutes left. I'm going to fly through them. The first one, I'm sure all of you saw this coming, EB born S versus ER, born B and others, and relevant for our purposes, I think more relevant, KG versus Minister of Home Affairs and others. 2023 ZA Constitutional Court 2032, that is still the neutral citation, and it is on Case Law Bundle, page 277. Essentially, what was found in this matter is that Section 7.3 claims are alive and well and living in South Africa. What was a Section 7.3 claim, folks? It was a redistribution of assets under certain circumstances. This remedy was essentially only available to those married prior to the Matrimonial Property Act 1984 coming into play. Why was this there? 1984, the Matrimonial Property Act brought in a very important development in our law, the accrual system. Sorry, let me just sort out my lighting on my camera. I see it's a bit topsy-turvy. Spouses before 84 could only marry out and out, nothing out of community, no sharing. And this was meant as a transitional arrangement to make sure that they are not prejudiced because they could not marry in terms of an antenuptial contract. Fast forward 30 years, Constitutional Court was faced with a matter of deciding whether this remedy should also be available to people that were married after 1984, and the Constitutional Court said yes. So we are seeing a revival of these claims, which to a large extent weren't litigated anymore because the generation that had married under the regime pre-1984 have either passed on or they have reached an advanced age where they've decided that murder might be cheaper or maybe just hang on. And we saw those matters simply not being litigated anymore up to KG versus Minister, and we will now see those Section 7.3 claims taking place more and more. Does this mean that all marriages are now in community of property? No. Does it mean that the accrual system is applicable to all these marriages? No, it does not. It means that a remedy for a transfer of ownership of an asset under certain circumstances, you have very high hoops to jump to get a claim such as this. Go read Section 7.3 of the Divorce Act, and it clearly sets it out. It's not just there for the asking, but this is now available to more people in terms of people married after 84 out and out can also exercise this remedy. Then let's look at some interesting case law regarding the ad hoc central authority for the Republic of SA and another versus Koch, which came in the kind of injury time in 2023. It made its way onto SAFLI, and I got the update on it from my daily Spartan case law update. And Louis, if you were watching, thanks again for keeping me up to speed. And for those of you who haven't had a look at Spartan case law, and they're not paying me, I'm just a fan of their service, go and have a look at Spartan case law. It's a very affordable, excellent tool to stay up to speed. They send out a daily mailer. So anyway, I got this. And what was very interesting and very heartening in terms of central authority versus Koch is that the Constitutional Court decided to uphold our treaty obligations and to return the child to the UK in this instance. And it looked very, very thoroughly at Article 13B of the Convention, dealing with the grave risk of physical or psychological harm, which is one of the justifications for a court not sending the child back. For those of you who follow international and expat children's law quite a bit, you will know that we've had quite a slew of judgments where the courts have kind of refused to, they have refused to send children back using very often Article 13B as justification. And the question before the Constitutional Court was, what is the limits of this? And the Constitutional Court, thank goodness, in my view, complied with our treaty rights, because I think we were, to a large extent, our courts, and respectfully said, obviously, were not following our treaty obligations as they should have. Difficulty with ad hoc central authority, and I set it out in a blog that I wrote on the topic, if you want to go and have a look at familialandlaw.co.za, is the effluxion of time since the application was brought up to the time of the child being sent back. And make no mistake, the court made significant safety kind of arrangements in terms of the timelines. I believe the child is only going back in March. There must be a transition period, and the granny must travel with the child to help them settle in, etc., etc. But it has been, I think, if memory serves, I think it was in 2019, mid-2019. So it was a good 4-5 years that the child has been separated from the father who's in the UK before the treaty rights of this father under the Hague were actually upheld. And what is the implication, and how devastating must it be for all parties involved to have that large effluxion of time that this court was going at a real kind of pedestrian pace through the legal system before the order was eventually granted by the Concord. The Concord, incidentally, folks, was not unanimous. If memory serves, I think it was 5 justices in favor of the return of the child and 4 against. So it was far from unanimous, but thankfully, I think sanity prevailed in terms of the larger picture of complying with our treaty obligations. But one must also be alive to the potentially devastating effect one can imagine it must have to all parties involved. Concord did make various statements obiter in terms of calling on the high courts to set up more measures to facilitate these things in future, and to make sure that these go through the courts a little bit quicker. So, what is a Hague application? It is not a long-term remedy. It's not a care and contact investigation. I think this is where a lot of the problem comes in, is a lot of courts have dealt with it, respectfully said, as a care and contact investigation. It is not. It is a case of restoring the status quo ante. If the child was abducted or wrongfully removed from a jurisdiction, and Article 13B, there's no risk of grave psychological or physical harm, or grave risk of harm, then that child must be returned under the treaty. Obviously, the Hague Convention, folks, not a perfect remedy, but thank goodness we as South Africa are still a signatory to that convention, because it really puts it gives families in South Africa, especially divided families, expat families, protections, provided that they travel to Hague countries. And one can imagine the upshot of what would happen if we do not comply with our obligations in terms of the Hague Convention. So, folks, 1:30 on the dot. I remind those of you who joined us late, please feel free to join the Think Legal WhatsApp groups. They are a free resource. You are welcome to join them. Follow the QR codes or the links that Nadia would have posted on StreamYard, as well as on Facebook, LinkedIn, and YouTube. Please, folks, consider supporting us by attending my Divorce 101 training, 3 nights, 2 hours per night, where we unpack divorce in South Africa in its entirety, 6 SARM NABFAM points for successful attendees. Use the promo code RECAP2023 for 20% off, valid until 21 January 2024. And another way that you can also support us is to purchase the course content that we went through today as a resource in your practice. It took quite a while to do, and I really would appreciate you considering that. I am going to stop with the webinar now. So thank you to everyone who has attended. I'm going to do a bit of a Q&A. If some of you have questions, I see that we have a few. Unfortunately, this platform does not allow me to add people to chat with me, but I'll go through whatever text there is. Anything that we haven't dealt with today, guys, please jump on our WhatsApp groups, come chat, have a discussion. You will see I am unfortunately not as active on the WhatsApp as I would like to be. Time has simply not permitted it, but we have some phenomenal legal minds on the group. I'm blown away by some of the input that we're getting there, and we have some phenomenal mental health practitioners, ADR practitioners, etc. on there, and there is always robust conversation going on. So please do go and chat there. So without further ado, to those who have to run back into the real world, thanks for joining us. We'll see you in the next one. I will be conceiving, preparing, and marketing the next free webinar during the course of next week. So do watch this space. And for those of you joining me at the end of February, or towards the end of February, for Divorce 101, please have a lovely time until then. And I look forward to seeing you then. Right, can I pop this on the screen? I'm going to pop on whoever asks questions. Lisma asks, just to clarify if I understand correctly, so the Children's Court and Regional Court can now provide consent from Republic or return of child. Lisma, no, they can, specifically cannot. Let me just go back to the relevant slide. And this is one of the big, I would say, lacunas or problems that we have in terms of the Children's Court at the moment, is that the Children's Court can assign guardianship, they can terminate guardianship, but in terms of Section 45, 3D and E, the departure, removal, or abduction of a child from the Republic, and applications requiring the return of a child to the Republic from abroad, i.e. Hague matters, are still within the exclusive purview of the High Court. Sure. Thank you so much, guys, to all the kind comments. I really appreciate all the kind words, guys. The flattery is going to give me such a big head. Let me quickly go through here and see. Have we got any other questions, comments, or queries, folks? I really would love to hear from you. If there is anything that I didn't deal with, please do feel free. Absolutely not. There's just too many thank you comments to react to. Right. I think I'm going to give a minute or two. If I have a new question popping up in the next minute or two, then I'll answer it. Otherwise, I'm going to slowly say goodbye to everybody and wish all of you a fantastic weekend. It was really lovely to chat with all of you and to share a little bit of what's happening in the spheres of family law at the moment. So from my side, thank you for attending. All the best to all of you in your practices during 2024, and I look forward to connecting with you on the WhatsApp. Tisetso, should a maintenance case drag on for 3 years if parties do not agree to a settlement? Oh, unfortunately, Tisetso, it shouldn't, but very often it does. That's the reality. The courts are very, very busy. We have a lot of very passionate people doing very, very hard work within those courts. Obviously, we have a lot of not so passionate people also, but let's focus on the positive. We have a lot of people working very hard, but the reality is that those courts are very much overburdened. How long it actually takes to go through the court is a question of the court, the facts, etc. Thank you. Barry, yeah, no problem. I'll share the link to the video on YouTube to the WhatsApp group. So those who want to attend are more than welcome to attend. Awesome stuff. Guys, that's it from me. I think from my side, everybody have a lovely weekend. I'll see you at the next one. Cheers for now and in